Excited to have two wonderful attorneys here from the Disability Rights Center on alternatives to guardianship. This is actually one of my favorite topics to talk about right now because there's so much misinformation that is going around, especially in the state of Kansas. So I'm really glad that these gentlemen could join us. So with us tonight, we have Lane Williams. Lane received his law degree from the University of Kansas and his Bachelor's of Arts degree in economics from Baker University. For 2 years during law school, Lane advised and represented inmates of Lansing State and Leavenworth federal prisons as a member of the Defender Project. He was a staff attorney for Kansas Legal Services in Pittsburgh and Topeka for 11.5 years and was in private practice in Aberdeen, Washington for 9 years before joining the Disability Rights Center as a staff attorney in 2004. He became legal director in 2009. Then we also have Kip Elliott. He received his Bachelor's of Arts degree in Education and Physiology from Fort Lewis College in Durango, Colorado. After teaching and running outdoor education programs, Kip went back to school and received his law degree from the University of Kansas. Kip worked for the Kansas Public Defender System for 9 years and was in private practice for 4 years. Kip has a state and federal experience in criminal trial practice, immigration, and civil rights. Kip is the president of the board for the Jefferson County Humane Society. I love that. Yay! Adopt, top. I will say that. Again, this is one of my favorite topics. I talk to families probably once a week on this topic lately. So I'm really excited to have them here. They're here to answer all questions. I think they have some information they're going to share with us first, and then we're going to open it up for questions. If you are watching this on Facebook, please know you put your questions in the question or in the comment section, and I promise to get those answered for you too. So welcome. I don't know who's going to take off first. I think Kip, maybe.
Lane's going to take off first. Are we screen
Lane's
sharing?
Take off first.
Do we have our screen?
No, you haven't shared that yet.
Oh, let me reshare here. Hold on.
Okay.
There we go. Not
You
sure
did
why.
a good job when we were in
There
practice.
we go. No, it's here. I just had to
All
find it. You got it now, right?
Yes.
Are our photos in the way? Are our screens in the way?
Nope, but we can
Okay.
see it really well.
Okay, perfect.
I'm at the
Perfect.
top. So. Welcome, everyone, and thanks for taking the time this evening to meet with us. We wanted to discuss alternatives to guardianship. Our presentation is not tremendously long, so we encourage everybody to, it's a discussion more than us sitting here talking to you for an hour and a half. Before talking about the alternatives to guardianship, we felt it was a good idea just to spend a little bit of time talking about what is a guardianship, and so that you can see a compare and contrast between the two forms of decision making. And I want to caution anybody who's from out of state, just to let you know, the information that we're providing tonight relates to guardianships and alternatives in the state of Kansas. Each state has its own statutory structure for guardianships and in some cases alternatives. Some are more expansive, some are not as expansive. So if this is for people out of state, this may be helpful for informational purposes, but don't rely on it as being this is what it is in the state in which you live. For that, you would want to consult with other legal authority, an attorney, or and another organization with materials that may be helpful for you. To start with, just want to explain just a little bit about.
Sorry, Lane, I want to interrupt real quick. I just want to remind you all, this is recording. So if you are watching the recording, this is the true information as of today, which is February 9th. I was going to say 1993. I don't know where I am going.
Might not have been much different back then.
2023. So there. Got that on the recording.
Okay. Thanks for reminding me. I was going to do that and I forgot. Guardianship's the most restrictive of the decision-making processes in Kansas because it limits more than other alternatives decisions that the ward, the person who's subject to the guardianship or the conservatorship or both, can make that are in his or her own best interest. You see, I want to say to begin with, all of the photos and all of the other art is not my doing, it's Kip's. He's much more creative, so it all goes to him. Guardianships are started with a petition by an individual who, and it just says any individual can file a petition for a guardianship to appoint, to become a guardian over an individual that they are saying does not have the capacity to make decisions on their own behalf. An individual, that part of the petition has to allege why the individual doesn't have that capacity. And in the statute, it's defined as an impairment whose ability to receive and evaluate information or to effectively communicate decisions or both without the use of assistive technologies or other supports is impaired to the point where they don't have the capacity to manage their own money, their estate, or to meet their own essential needs for health, safety, and welfare. That's a very subjective definition. It's whatever evidence is presented to the court. In some cases, it may not be very much evidence, but the start is a petition, and it's filed by the individual wanting to establish the guardianship, and in some cases, conservatorship, a conservatorship being the authority to make decisions over a person's finances, property, bank accounts, assets of that nature. After filing, there are orders that can be entered by the judge. And the first order would be to schedule the time for when the petition is going to be heard, a trial or a hearing. And that order includes a requirement for the ward to appear unless there's a determination that the ward, for one reason or another, doesn't need to be there, either because it is injurious to her health or welfare, or that person waives the right to appear. And then if there's not one already filed with the petition, then the judge would order to have somebody who's independent to make an evaluation of that individual to determine whether, what capacity, what abilities that person has. And another one of the orders is that the court orders an attorney to be appointed to represent the interests of the ward, to represent the ward in court, not the best interest, but the ward in herself, what the ward wants, the proposed ward rather wants, instead of what is in that attorney's mind best for the ward, proposed ward. And that attorney is required to meet with the individual who may be subject to that guardianship. One of the issues that always comes up in our office, and what we see a lot of times, when a court appoints somebody, the court is appointing it and paying that attorney out of the county funds that are in the court system. It's not a lot, and a lot of times the attorneys do not spend a lot of time working with the individual. And in many cases, we see as a matter of practice that the attorney who is required to meet with the ward will have a brief meeting with that individual and then report back to the court that in more cases than not, that the proposed ward does not need to appear at the final hearing. And so it's just file the required evaluation, have a time set for the hearing. The attorney for the individual reports back, and if that attorney says this person doesn't need to appear, waived it, or it's not a good idea for that person to appear, the judge can sign off on it on an order appointing a guardian for that individual in no time at all, with a very short hearing. But the individual who's subject to that has the right to have a trial. In fact, has the right to have it in front of a jury. And that's a little known fact that most attorneys, I think, in practice, don't sit and talk with the proposed ward for very long about. And I'm not bragging against the attorneys who represent those individuals, but it's just a matter of practice that it doesn't happen very often.
I'll rag against him later. Lane won't do it, but I will.
Yeah, Kip.
I'll rag against him. No problem.
Yeah, Kip is a member of the Judicial Council who's trying to do some major changes to the guardianship statutes, and has some good opinions about the process right now. So there is that alternative, although, like I say, I'm not sure I've ever seen it. But it's just a little known fact of a right that a person who could be subject to a guardianship can assert if he or she had known. Standard for finding somebody in need of a guardian is that they're what's called clear and convincing evidence that that person needs a guardian. That is a very high bar to get over if it's contested. At least from a legal standpoint, that's much higher than more likely than not. Not quite as high as the standard in a criminal trial, but it's more evidence than just, oh, it looks like it versus it doesn't look like it. 51 versus 49 is higher than that. As a practical matter, again, many hearings are not contested, and it's just a matter of course that a guardianship is going to be entered. Once those orders are entered for the person to become a guardian over an individual, the powers of the guardian can be extensive unless there are findings that the individual does have some abilities to make his or her own decisions in certain areas. And the statutes state that a guardian is supposed to take that into consideration. It doesn't happen as often as we'd like to see it, but it's there if the ward at that time, after being appointed a guardian, has the ability to assert that there are things that he or she can do that don't require the guardian to interfere in those decisions. A lot of it depends upon whether the guardian is willing to do that. Some of it's personality, some of it's just understanding what the rules are. And in some cases, if there's not a willingness to do that, a ward has the right to go to court to set up what's called a guardianship plan. which would, I'm not sure which one is the guardian and which one's the ward in that picture, or is it, but anyway.
Oh, yeah, I think the big one's the guardian.
Yeah.
They're both animals, lame.
Yeah. A lot of times, the ward has the opportunity to say, these are the things that I should be able to make decisions on. And a lot in our case, when we represent individuals in filing for guardianship plans, the goal is to set the parameters now with the understanding and the proposal to expand those abilities as time goes on, and ultimately have the court take a look at whether the guardianship is even needed anymore. So there are ways in which to assert that a guardianship doesn't have to be as restrictive as a guardian would like it to be, or it believes it should be. But it often takes having the board have an advocate doing that. And because the ward often doesn't have any money, it makes it much more difficult. But it's there for consideration in certain circumstances. Ending a guardianship is not nearly as easy as establishing one, especially if the guardian is opposed. Statute says if the ward files a petition and submits evidence to establish, at least on the surface, that there's a question whether the guardianship should continue, the judge has to can only continue that guardianship if the judge continues to find that there's clear and convincing evidence that it should continue. It's not like the ward has to come in and show the opposite, that they have overwhelming evidence to establish that the guardianship should end. But again, as a practical matter, that depending on the court, that may or may not be very clearly defined. But wards do have that opportunity, but it's difficult at times, particularly if the guardian is opposed to that. It takes getting new evaluations, and establishing that things have changed, and the ward now has the capacity to make those decisions on his or her own. Now, the best thing to avoid all of this is to set up alternatives, decision-making authority that the individual makes before there's a question about whether somebody is filing a petition for guardianship. And that's you, Kip.
That's me. Yeah, I wasn't real sure. Like, we wanted to touch a little bit briefly on guardianships, and because a lot of people that call us at the Disability Rights Center are people that have guardians, things aren't going well, or somebody's filed a petition for a guardianship and they don't want a guardian. And so, yeah, there's so many important things that should happen early on. And what happens with when somebody files a petition for a guardian, the court can do preliminary orders. So the court can actually, that same day that the petition is filed, make that person a temporary guardian with all of these crazy powers. And most people don't know that. And they're stuck unless somebody gets involved and says, whoa, time out. Maybe the court doesn't even have the full story, which generally they don't, right? They've just got a piece of paper in front of them. So guardianships are very, very, very intrusive, right? I mean, like Stephanie said, I was a public defender for a long time. And, one of the most important things that, part of that job is that we all have these constitutional rights, and we have the right to liberty, right? Guardianships can take that away from you. And so, you know, for the most part, DRC is very much against guardianships, if we can find alternatives, especially. You know, and one of the very interesting thing that's going on right now that we're seeing is, and I think part of it is that we have an aging population, right? We hear that term all the time. But we're seeing more and more guardianships on folks that are older, right? And the Department of Justice and some other elder law organizations are really coming out and doing a lot of good stuff on helping people understand that this older person maybe they seem like they don't understand what's going on, but maybe there's a good reason for that, and maybe it's temporary. And so, you know, I think it's what we would like to get across, I think, today is that there are alternatives, and sometimes it takes work to get those alternatives in place. But, and I don't know if there's anybody joining us today that has a guardian. You know, I think that the other thing we've seen over the years is that, like, if somebody had a foster child, right? And boy, they're told when right before that kiddo turns 18, you need to become a guardian. We need to put that over that person. Well, why? Because they're in foster care, because they're turning 18. That's not a good reason. But sadly, a lot of foster parents who are putting their life out there and doing everything they can, they think they have to do that because that's kind of what's pounded into them. So that's an area that we've seen a lot of, and you know, we want to try to do that. But Lane mentioned, and I'm actually on the Kansas Judicial Council for Guardianship and Conservatorship, the advisory council. We just started our 3rd year on this group because we're looking over the uniform code for guardianships and conservatorships, which all but a handful of states have adopted. Kansas is one of the ones that has not. But we are really trying to incorporate that because there's a lot of good stuff in that. And one of the parts of that is the courts looking at alternatives, where in Kansas, there's nothing really there that says, hey, judge, maybe you look at alternatives, or judge needs to say to these people petitioning, well, Lane, you petitioned put a guardianship on Kip. Have you looked at alternatives? Oh, no, of course not. So, you know, we're really hoping that once we finish what we're doing, that there'll be some good changes in that, as well as some supported decision-making type things that we're going to do. So, but yeah, it's a scary process when it happens to folks, when they're all of a sudden they're told they have a guardian and they're like, well, wait a minute, I want to go out to the bar with my buddies tonight. Oh, sorry, you can't go, right? And here's one of my favorite things about Kansas guardianships. In Kansas, the guardian cannot deny a person's request to get married. They have no power to do that. So the guardian cannot say to the person with the disability or the ward, I'm sorry, you can't get married. They can't do that. They don't have that power. That's kind of good, right? But here's the other part of that. They can prevent you from ever seeing that person or living with that person. Oh yeah, go ahead and get married, but sorry, you can't see that person ever again. So yeah, there's kind of crazy stuff out there. But by all means, I mean, you know, we're all very invested at DRC and helping people understand what's going on and, you know, should I be doing this? What should I do? So, and what I'm gonna hit next is I want you to meet Austin. And Austin is an incredible young man. And his parents were his guardians for a long time. And he no longer has guardians, but here's a little bit about his story. And he's really an incredible guy. So let me play that.
Is there sound, Kip? Because I don't hear anything.
Yeah, we're hearing it. Hold on.
We're not hearing it here.
Hold on. I wonder why. Let me try something else.
Were others hearing it? You can just put a message in the chat. Maybe it was just me.
Let's try again.
No.
That's odd. I'm not sure why that is not working.
Where's your tech guy?
Yeah.
You know, it's weird because I've used this in the past and it hasn't been a problem. So I don't know if there's something going on in the slideshow itself right now. I'm going to stop my share for just a minute and see if I got something wrong in there.
And just a reminder to those on Zoom, because the slides are down, those of us with our camera on right now are on Facebook, so they can see us on Facebook. So it's just Kip, Lane, and I. So, but I wanted to remind you in case you thought you were going to turn on your camera. So I'll ask a question, Lane, while Kip is doing that. You know, let's say the ward, I don't think families understand this too. Like, the ward is the ward of the state. That's just because you're guardian of that individual doesn't mean that child is yours still, right? Like, it is the ward of the state. And should all the guardians disappear, like maybe you had in your will 3 or 4 different guardians you'd like for that person to have, and they have all sadly been hit by a bus or something else happens, the state chooses who will be the next guardian. Am I correct?
In some states that's possible, but not in Kansas.
So how does it work in Kansas?
Well, in Kansas, the ward is subject to what's called the jurisdiction of the court, but there's not like a process if something unforeseen happens to the guardian that the court or the state steps in and finds a guardian for you, for that individual. That person is in limbo. And in fact, coincidentally, had a conversation with the law office today. The attorney is guardian for several individuals, has terminal cancer, cannot continue, and there is no process for March 1 when that individual is no longer practicing law and no longer functionally as the guardian, although within the court proceeding itself, that person is still listed as the guardian. We've had another client whose the guardian passed away years ago, and there's been no process. So what
happens in that situation?
As a practical matter, if there's no guardianship, the individual, depending on that person's capacity, may functionally live as though there is no guardianship. But if that person doesn't have that functional capacity, or there's a bank account that the guardian and conservator, also named as conservator, was managing, the bank, that person, that ward conservatee, no longer has access to that money and can't pay bills because it sits there. In many cases, Social Security disability money goes into there, or retirement money goes into there, but the person has no legal right to access it unless previously the conservator authorized the bank for that individual to be on the account, and the individual's on the account, but also to have authority to withdraw it. As a practical matter, they're stuck. They could lose their home. They could lose where they're living. They could get kicked out of a nursing.
Oh my goodness.
The only process that's procedurally is available, or just in the state right now, is what's called the Kansas Guardianship program, which is when Child Protective Services or Adult Protective Services gets a report of an individual at risk, makes a finding that that person's at risk, refers it to that program for that area, then the program finds a volunteer to be the guardian. Sometimes there's a list that they have, sometimes there's not. Our experience is we were trying to sometimes have to replace a guardian, and the ward wants that replacement, and they're okay with it. There may not be anybody available for years.
So that's even worse than not having anybody.
Yeah.
Go ahead, Kip.
It's just messed up in some ways. Yeah, there's a big gap.
Yeah. There was a question in the box. What if you attained guardianship in Kansas, but then moved to another state?
It's up to that state that you move to, whether the Kansas guardianship is effective. There's a term, it's called full faith and credit. Some states Kansas did this a few years ago, adopted a statute or passed a statute that states that a guardianship, say in Oklahoma, and then the ward and the guardian moved to Kansas, that people in banks, service providers in Kansas can rely on that guardianship in Oklahoma, give it full faith and credit without having to go through a procedure in a Kansas court. Previously, you had to file it in Kansas, have the court adopted in that area in the county in which the individual is living. But vice versa, it just depends upon that state. Some states will do that. Some states will say, if you've got one in Kansas, great, but you're going to have to bring it and file it here.
Start over again here.
Well, it's not necessarily a start over. It's at least getting it into the court system so that they have the records, the actual record there. That's what it was in Kansas. And every state, like I say, can be potentially more restrictive, less restrictive, or have a process in which there's no requirement to go through the court system now, like Kansas has now. But the one problem with that is that if the ward wants to make a change in the guardianship, you still have to file it in Kansas because the court's got nothing to work with otherwise. And we've run into that where guardians are reluctant to do anything like that, and so it can be a mess.
Kip, you think we got this?
I don't know. Are you seeing a full screen or just?
I am not seeing your full screen.
Yeah, I don't like that either. Now I've got my whole PowerPoint messed up. Jeez.
Could be that my screen's on.
I don't think so. Just trying to get back to, oh, I know. Hold on a minute. I can't get up here because of this. Let's try this for a second. Let me go down. It may not play. I don't know why it's not doing it. We'll try one more time. Oh, yeah. Sorry about that, guys. I don't know why it's not doing that. Something's happened. But Austin worked with us and was able to terminate his guardianship. And one of the things that Austin talks about is, having supports in his life to help him with things, but he gets to make his own decisions, right? And so, that's one of the things that we want to talk about tonight is supported decision making. But before we do that, quickly, and this actually a durable power of attorney for healthcare or for financial issues can be part of that supported decision making. So, you can appoint an agent to help you make decisions with healthcare, for example.
Can you explain what an agent would be?
An agent could be anybody. It can be your partner, your friend, your parent, right? It can be anybody. It doesn't have to be an attorney. And so, if, for example, right? I mean, I have durable power of attorney set up for both my healthcare and my financial, and my partner Mary is the agent, right? Mine don't go into effect unless I'm not able to make decisions, right? Mary would say that's every day, but and it's kind of like a lot of people have living wills, right? Where they're making decisions ahead of time on what they want to happen if maybe they're in a bad accident and they're not going to be able to come off of life support or whatever. And so a lot of people will make those plans ahead of time. And some people, you can do that actually in a power of attorney as well for healthcare. Power of attorney for financial, and I'm not going to go into that a whole lot. It's, and actually, let me go to the next slide. That might help. I should have done that next. So it's an agent is somebody to speak on your behalf. But for healthcare anyway, it's only if you become incapacitated due to illness or injury. Now, that's what we call a springing, right? It springs into effect if you can't make those decisions. I have had a few times where somebody wanted to do a durable power of attorney for healthcare and wanted it to go into effect immediately. And we were able to put parameters around that. But I can see a few scenarios for that. We know, I mean, we talk a lot more about it than we've ever talked about before, but with mental health issues, right? And, I've actually had a client who said he wants his brother or whoever to be his durable power of attorney for healthcare, but he wants it to be effective now for certain circumstances. And he's, we talked a lot about that. And he said, the problem is, and I've struggled with this my whole life, is that I may just quit taking my meds. I may just decide, hey, I'm going to go out and do whatever the heck I want to do. And I'm going to go downhill fast. But I want my brother to be able to step in right then and there without somebody having to find that I'm incapacitated to help me get into crisis treatment or whatever. So it's not common to have a durable power of attorney for healthcare that's effective immediately, but there are circumstances, and you don't like anything. There, you'll find forms online, right? I'm not a big fan of those because they may not fit you. And I think at the very minimum, you need to talk to an attorney to find out what do I need? What do I want to happen? Because you find a form online and it's like, okay, fill out the blanks here. That may not fit you. And there's nobody that can say, oh, you can't add another sentence to that, right? Sure you can. You can personalize these things. I had somebody come to me recently who has a durable power of attorney on somebody else and for healthcare, and she was being told by a nursing home that they were going to discharge him and she had to take him somewhere. And she's like, wait a minute, I don't have to do that. So I said, well, let me look at your documents. It turns out it was a durable power of attorney, but only when that person became incapacitated. So I'm like, you have no authority at all. So yeah, and that was a good thing in this case, but you know, they can help you if you have a living will that you filled out and then you become incapacitated, the person, your agent, cannot revoke those wishes, right? So
I think a lot of our families are, you know, really concerned around the healthcare too, and, you know, and maybe why they go to guardianship. So like how this can help them understand that no, they don't have to go to guardianship, but they can still help their son or daughter with medical decisions around this, using this document.
Yeah, and it can be drawn up for those very specific individual needs, right? So maybe you know, I'm the agent for Lane, right? And he's fine, except he has super fear of a dentist, right? And there's no way in hell he's going to ever go to the dentist. And he knows that. But maybe in our power of attorney, it does pull that out of there and say that I can help, I can seek dental treatment for Lane, right? So we use each other a lot for stuff.
Another example could be that medical providers are reluctant to share medical information without a specific release, but within the durable power of attorney, I could say I appoint my parents as my agents for the purposes of being able to access all of my medical information, have access to all of my providers, to obtain all the information that that my providers would be giving me, and to help me make the decisions. But in the end, I'm the one who makes the decision as long as I have the capacity to do so. And so it's clearly set out, and that helps the provider, the medical provider, understand that they don't have to put that wall up there of you have to have a release, and then we don't have to talk with you about anything other than just to give you the records. It sets, you know, it can help the provider too, because it opens up those discussions that can help that person.
Yep,
That's great.
That's a really good example, Lane. And you know, let me see if did I put a slide on? Yeah, I mean, here's a little more. You have to be at least 18 years old and be competent, right? To sign a durable power of attorney, right? And there's things that, you know, there should be limitations. You're treating healthcare provider, your employee, the owner of a company, the directors or whatever. They should not do that, right? unless they're related to you maybe by blood or marriage or something like that. But usually if somebody comes to us wanting to do a DPOE, we're going to sit down with that person without the possible agent, right? We're going to help figure that out. We as attorneys have to determine whether they're competent, right? And usually they are, but then we also want to really talk to them about who do you want to help you with these decisions, right? So this is really kind of part of supported decision making in a way, and it can be part of that. Your agent should be somebody that you trust, right? And who knows you. I mean, you don't want to go down to the local McDonald's and grab somebody out of their car and get them to be your agent. They don't know you. You know, that they'll advocate for you and they'll honor your wishes. You know, what's sad is that we don't put this in as part of the guardianship, right? Guardians should have these same things going on. So yeah, those are important. And again, you know, this should be something that, you know, I would encourage people to seek out legal assistance for this. And we do quite a bit of this. And, you know, we can certainly help with this kind of thing. And just again, this is just durable power of attorney for healthcare to help make just medical decisions if you were to become incapacitated. Now, for financial, it might be durable, which means I get to make all my financial decisions unless I become incapacitated, which is a springing again, or non-durable, right? Which means that, okay, you know, I don't handle my money well at all, and I know that, right? I'm just not good at it. So I'm going to ask Lane to be my financial agent for this. And I'm going to give him those powers to do that, because when he gives me money, I go buy candy, right? That's what I do. I'm not going to pay rent. I'm going to go buy candy. So, and I know that. So, you know, and sometimes, you know, when you talk about alternatives to guardianships, a lot of times we have folks who they don't need a guardian, and you know, maybe they have a payee already, right, that handles their financial. So that's kind of, you know, handled, and maybe they do need the payee. Maybe that's something we address later. But these are really great tools. And Lane's gone into court. I've gone into court with people that want to terminate guardianships. And we go in there to the judge and we say, listen, not only do we have an evaluation that this person does not need a guardian, but here's some things in place to help this person. DPOAs, or they drag in their 20 friends who are willing to help them, right? So these can be part of that toolkit, right? So this kind of, and again, I think supported decision making, these are part of that even, right? Go ahead.
There was a question from Facebook. At the age of 18, can parents still go to doctor with their child if no guardianship? I know the answer, but.
Yeah, I mean, if the child says no, no. And a doctor shouldn't allow that.
But if the child's okay with that, then.
Yeah, I mean,
fine.
you know, if you're 80 and you want your, you know, person to go in there, yeah. But, you know, and the doctor, and I think doctors are better at this than they've ever been. If they know they have a patient who's 18 or older, hey, you know, you're considered an adult now. Do you want mommy and daddy in here? So, yeah, no. But now,
some providers may ask for them to sign some form or a document, not necessarily a power of attorney, but something to put into their records to document that the patient, the child, you know, the 18-year-old adult is authorizing that the parents to continue to work with his medical provider.
right. And that's a good question. Good question, Facebook. So supported decision making. This is like that new kind of fangled term, right? We're all hearing this more and more, but it's been around forever, right? We've done it our whole lives. So it's kind of just, okay, let's really think about it in terms of somebody that instead of having a guardian, maybe we just need to build this support around them. Okay, but it's things that we've done. It's not newfangled things. I mean, you know, I tend to joke a lot, but my partner Mary, I think she considers that she does supported decision making with me every 5 minutes. No, Kip, I think you should do this or whatever. But anyway, it just means in this context that the way an adult with a disability or diminished capacity has made or is making his or her own decisions by using friends, family members, professionals, other people that he or she trusts, right? And that person, and that's where you build this kind of community around you, right? It might even be a therapist that you've been working with for a long time, who is part of that team of people that you can go to. But these people will help you understand, hey, what are the issues going on? What are my choices, right? So sometimes it's simple as, it's like, I'm sure most of us have been in a situation where a friend or a family member wants to buy a car, a used car, okay? And they're like, I don't know whether I should buy this car or not. I mean, they start asking people around them, do you know anything about these Ford Pintos that used to blow up? Or, you know what I'm saying? I mean, things like that, right? We all have areas we don't know a lot about. So even if we don't have disabilities, we do that. And that's what this is. And we ask questions. You should ask questions. And if I have a question, I want to make sure that these people that I've surrounded myself with communicate to me in a way that helps me understand, right? And and it could also be supporting me in communicating that decision to other people, right? So, because we run into that. I mean, I think maybe a good example is signing a lease for an apartment. And it's like, you're 18 or 19, maybe you have a disability, maybe you have, some issue with speech or hearing or whatever. And this apartment landlord or whatever is like, oh, no, I'm not sure that you're able to do this. Okay, that's ridiculous. But having those people around you who can help you and help communicate with other people sometimes is a good thing, right? And I don't know, facilitate the exercise of decisions. And that just, again, it's stuff we've done our whole lives, right? If you all think about it, right? Think about you as a child, right? And you had to buy that t-shirt or those shoes, right? And you're going to have maybe your parents kind of discussing that with you a little bit. It's like, well, maybe we shouldn't buy you $300 pairs of shoes right now because the last pair you had for a day and you lost them, right? Just that kind of communications without being paternal, okay? And so I don't know if that helps a little bit, but why does it matter? And I think that the reason it matters is it starts with understanding the history of disability in the United States, right? And that for a very, very long time, people with intellectual and developmental disability lived in institutions. And there was no opportunity in these institutions for self decision making. And everybody made decisions for folks, reproductive rights even, which kind of scary, and financial decisions, whether or not you can be employed, and a lot of others. But in the 60s, there were growing concerns, and it all came out of these terrible, terrible conditions and things that were happening to people in a place called Willowbrook State School. And that really pushed forward where we are now. But it took till the 60s to do that. And there was a huge shift at that time towards community living. All right. And so, and I'm not going to read all this to you, but it was a big deal. And we're still working on that, right? I mean, we're still trying to work with folks that maybe they're in a group home or whatever, and their guardian doesn't want them to be more independent. So that's something that we work on and work through quite a bit is, wait a minute, guardian, you have an obligation to make sure that that person is living in the least restrictive environment. Okay. And so that's a really important thing that we've moved towards looking at that. So here are some things. What is supported decision making and what is not? Again, I've already talked about most of these. It presumes, it assumes that the capacity or the people with disabilities, they have capacity to make decisions. They can do it. You know, they may have to do it in a little bit different way, but they can do it. And we want to make sure that that person, you know, is growing and moving and doing things that they want to do, and that all of this is voluntary. There's not a judge looking over people saying, you have to do this or you have to do that. But it's all about helping people, if they want that help, to make decisions. And, you know, one of the cool things about developing this kind of group of people around you, if you're appointed a guardian and you don't like that guardian, well, maybe you like that guardian, right? At first, but things go south and you don't like that guardian anymore. You can't just get rid of that guardian. You can't just say, go away. But under supported decision making, if Stephanie is one of my people and she's been great, but now she won't let me wear baseball hats, I'm like, okay, Stephanie, you're out of my group, right? You're not in my group. But it allows people to take risks, to make mistakes, right? It's really interesting because we hear this a lot. We'll get a call about somebody that doesn't want a guardian, and you know, we'll oftentimes kind of talk through that, and then if they give us permission, maybe we'll have a conversation with the guardian, right? And we'll say, well, why does Sam need a guardian? Well, if Sam doesn't have a guardian, he's going to be drinking. Are you with Sam 24/7? How are you preventing Sam from going out and having a drink? You're not. And yet you're not allowing Sam to kind of figure that out. So that's part of it. So what it's not, we don't presume that a person with a disability is not competent. It's not like set things that have to happen, you know, every single minute of every day. It's not ordered by a court. It's not a way to coerce people with a disability to do certain things. And I think that's really important, because a lot of people that have disabilities and have a guardian, they can make some decisions on their own, absolutely. But, and I'm sure we've all seen this to some extent, it's also with some folks, especially with developmental disabilities, is it's also easy to sway that person to go one way or the other, right? And we have to be extremely careful about that. And so you have this group of people surrounding and supporting you that know that. They're going to go, wait, stop it. You know, you're leading Kip down that path. Stop doing that. That's not what he wants. Okay. He doesn't want to wear pink shirts. Stop it. Okay. So, you know, those are kind of some of the things, what it is not. You know, it is very empowering to have supported decision making. That person they retain all their rights. It increases their self-esteem, their self-worth, their personal growth, right? And everyday experiences, right? Not one of us sitting out here tonight can say we didn't screw up once in a while, right? Okay, I can't see hands. That's probably a good thing. But yeah, I mean, we all do. We all make mistakes. Some of them worse than others, but we make mistakes. That's part of life. Okay, but it's okay. It's part of growing. And I think the reduces stigma is an important thing. You know, it's awful for some people to have to say, well, I can't do that because I have a guardian. Oh, yuck. You know, so, but there is absolutely no reason that people with disabilities should not be viewed as being capable of contributing to their own life, to our lives, right? So it is an important process. I think it's and we've kind of talked about this, but who can be one? Caregivers, friends, mentors, religious people, you know, maybe you have a pastor or somebody that you really trust, a sibling. But it's important that that person is somebody you trust and who understands what their role is, right? Their role is to support you, not to tell you what to do, right? But to support you, right? Now, it doesn't mean that I might choose somebody to be on my team, but I might choose Lane because I know that Lane doesn't have a problem saying to me, Kip, not a good idea. If you want to do that, absolutely, probably not a good idea. And here's why. So you don't have to have yes people around you, right? But you can have people that you trust who are going to be honest with you. A lot of people have, I don't know where they came up with this, between 4 and 7 supporters. I don't know. I don't know.
I don't think there's any set.
There's no set, but I think having a variety is a good thing, right? And you can have, maybe you have different people that do different things for you, right? Maybe you have somebody that, you know, I really think this guy or this woman is really good at finances. And when I have those kind of issues, I'm going to go to him or her, right? But they're not good at helping me choose a car. So I don't want them to do that. But you know, that's what I mean. You that's why you may have various people. So I think some of these slides, I apologize, are a little bit redundant, but they do support you in making your own decisions. So they're not making decisions for you, but they may give you the pros and cons. Yeah, here's a good thing about that. Maybe not such a good thing. And again, we talked about helping communicate your decisions to other people. They might attend appointments with you. And there again, if it's a medical appointment, you know, and you want them there, they may have to sign something in the doctor's office. You know, you might have to sign something to allow them to be with you. But that's certainly a good possibility. And the final decision is always left to the person with a disability, okay? In supported decision making, it's always left up to them. Maybe they don't make the best decision, right? Maybe they buy that Ford Pinto and it blows up. But And it's okay to agree or disagree, but mainly they need to respect that person with the disability and keep in mind that you're there to support them in making their decision. So yeah, it's not something that's new. I can tell you that on this judicial council, that's one of the things that we're hoping will come out of this is that's may very well be part of the court saying, when that guardianship petition is in front of the judge saying, wait a minute, what have you done? What are some alternatives to a guardian here? So hopefully that's going to become more and more of a thing. All right, we're going to say thank you, but we're going to open this to questions.
Yeah, if you have any questions, again, on Facebook or here, please turn your mic on and feel free to ask, or put them in the chat and I'll ask them for you. You know, I really want to talk about like just the documents. So supported decision making, and this I think might have families feeling a little bit more comfortable at the point of, you know, let's try supported decision making instead of going straight to guardianship for a while, right? Because that's what I try to do when I talk to families is what can we do before guardianship? And so really, they really would only need like the durable power of attorney for healthcare and financial, right?
Those are
Or
those are the two statutorily recognized documents, but there's a lot of flexibility in how you structure those documents to basically include what Kip's talking about with the informed decision-making process. You can, you know, to me, my way of thinking, those documents are fluid, and the individual who has that capability of making those choices and the capacity to engage and put it together can tell the person who's preparing it, this is what I want this person to be able to do and have access, so that the world knows that this person can act with me on certain things. It's like the example before this 18-year-old son with disabilities, but wanting parents to be involved in the process of him making those choices within that durable power of attorney, and making it clear these are the limits to what my parents can do, but here's the limits of, you know, here's what they can do to help me. So
okay. We have a question. What if your child only has the intellectual capacity of about a 6-year-old and couldn't even understand the idea of guardianship versus supported decision making?
well, in order to authorize a durable power of attorney, that person has to have the ability to understand what's being written and what that person is signing. When we sit down with somebody, it's an individual process that the attorneys in the office follow in meeting with that individual, finding out, you know, just talking with them to get an understanding of what they want to do. And then if we have the document, you know, a form document or just a, you know, a standard durable power of attorney with the standard language in it, we offer it to that individual to take a look at and try to explain in his or her own words what that means to them. And then we have to make the choice ourselves, make the decision based on our conversation, whether we can prepare the document formally for that individual to sign. Because it's up, you know, it's ultimately, ethically, we can't do that. If the person is not competent to even engage, to understand it or engage us to do the work, then that document is not valid. And
so then you would encourage them to do guardianship?
Well, yeah. We don't encourage anybody. We point out the alternatives. Okay, from our office standpoint, we only represent clients with disabilities.
Right.
So an 18-year-old with limited capacity such as you described, and the parents come in to our office, and all three of them are in our office, and the parents are saying, you know, we think he needs a guardian, and we'd like to have you represent him in doing that. We're only going to represent person with the disability, but only after meeting with that individual on his or her own in private to gauge what that individual wants. And if that individual can't tell us, that person can't engage us, and we don't represent guardians because they're not the person with the disability in our, and that's the way.
I understand your office couldn't, but you would, I mean, probably encourage that individual to seek a guardian then? I mean, since you're only.
We can't do that.
We wouldn't do
We
that,
can't.
but we certainly understand, right? I mean, we've all, Lane and I have both represented clients with guardians in non-related guardianship cases, because that client doesn't have capacity to engage us. So we've got to go through the guardian for that personal injury or something like that, right? I mean, both Lane and I understand that there are times that somebody needs a guardian, because if they have that 6-year-old mentality or whatever, and they can't make those decisions. So yeah, I mean, are we saying, I'm not saying that people never need a guardian, right? But I think that, you know, those are the extremes, right? I mean, it's kind of that, you know, when they do have some capacity there, you know.
Yeah, and that's the thing, is I know that a lot of families, and that's another area I want to change from the medical community, you know, and helping those families understand right from the get-go that, you know, look, your child can make some decisions in, you know, when in the doctor's office, when they come in and, you know, the doctor says, hey, Stephanie, what have you been doing since the last time I saw you? And I say something, and then maybe my mom will come in and fill in all the blanks for the doctor, but at least I'm showing I can and share some information. And as we grow that child, you know, and everybody does it, not just the doctors, but it starts at the doctor's office, right? And encourage the parent that they're doing a well job, then maybe we won't be seeing that at 18 either, because the parent might see the child like, what are you talking about? My child can make decisions on their own. He's been doing it since, you know, seeing, I'll pick on a doctor I know is on here, Dr. Genevieve, since they were 2 years old, you know, so like, I know that they can make decisions. So I want to change the conversation on that end too, as well.
And I think that's really important, in that, you know, that's where too, as you know, if you have somebody who's very young and developmentally disabled to some extent, but that maybe improves as they get older, right? And maybe they can't make the same decisions that their peers might be making, but they can make some. And, you know, we often see that the family members are the ones that become those guardians, but they're also generally the ones that care a lot about them, and they're going to allow that, right?
Right.
You know, so
I just think we as parents, and I don't want to hog the conversation, but I think we as parents, you know, are so beat down by the negatives that we've seen our whole lives with the child's whole life with, you know, you got to have negatives to have a diagnosis. You got to have negatives to qualify for services. You got to have negatives to keep services. You got to have negatives for this at school, that we hear that and we're beat down. It's like somebody's got to change the other sound. If we're going to keep hearing that, we got to hear the positives from somewhere else. And I think there's a lot of places, and I'm not just going to pick on doctors and say that. I just happen to be at a health system that I can, you know, be that part of that. And so I want to help change that narrative from the beginning of the child life. So we do have another question.
Well, really quick though, you said something early, and I wanted to bring this up. In a guardianship, if there is a guardianship in place, right? but that
Mhm.
person is moving towards more independence. There's absolutely no reason you can't start the supported decision-making as part of that guardianship. You can build that into it.
Yeah.
Yeah.
I have used guardianship with my son since like day one. Yeah.
You could give that informal authority of that going to court and setting up a formalized plan. You can just write out a
Show
document.
that.
If you want to give it to the bank saying, hey, it's okay for him to take out up to $50 a week.
That's the one place we're gonna keep a power of attorney is finance, and even he knows that. He's like,
Bad example, I'm sorry.
yeah, no, I'm like, get too many charges.
Yeah.
But no, seriously, here's another question. Can a person under guardianship vote in state and national elections?
Yes.
Yeah.
In
I knew
Kansas.
Yes.
Without qualification.
it.
It didn't used to be that way for people with mental health issues, but the Constitution was changed and it was
Great.
done.
But let me just say this, because this came up during one of our last voting cycles. Actually had somebody call and say, okay, we got absentee ballot for my son, who's 18 or older, and can I just go ahead and fill that out and send it in? It's like, well, no. Well, my son doesn't understand any of this. And I'm like, well, if your son doesn't understand, then you can't do that. So.
Yeah. I had moved my parents. I'm
Can't ask.
sorry.
The individual can't, the voter can ask for help,
Oh, right.
even inside the voting booth.
Yep.
It's the voter's choice.
Yeah, my son and I talk all the time about elections. He's been voting with me since he was 1. Out of necessity, he had to come with me, and he loves to vote. So good on him. But I do remember, speaking of elderly, I had moved my parents here in 2019, and they voted in the 2020 election, and I'm like, that's it, you're done after this. Especially my stepmother has Alzheimer's, so I knew that she wouldn't physically understand how to vote after that. So I'm like, no, we don't need any more absentee ballots on that.
Legally,
She wouldn't be
has
able to.
right.
I know, but she wouldn't be able to fill it out.
Whoa, she can have help filling it out.
Yeah, but she can't sign her name.
Doesn't matter. You can have an X.
Even if she can't sign her name, like, I mean, literally, she doesn't
Right.
even know her name anymore to write it. She
Well,
doesn't know her name to write it. The last time at the doctor's office, she was told to write her name and she couldn't write her name.
Well, maybe she doesn't know her name, but does that mean that she doesn't understand what's going on? Like Joe is running against Sam. Maybe she does understand that.
From a legal standpoint, an individual with a disability, no matter the extent of that disability, under the law, still has that right to vote.
Okay.
Your situation may be, as a practical matter, there may be a lot of barriers, but just as a matter of law, a person.
Oh, I understand. I absolutely understand that.
Yeah, good question.
Yeah.
So I have another question. Let's see if there's any. Somebody took yourself off of mute, so I want to see if they have a question. No. Okay. I'll keep asking them then. I always have a world of questions. Let's talk about the process of guardianship. Where I am in the Autism Center at KU Medical Center, and we have developmental pediatricians and developmental medicine. And I know a lot of our psychologists and psychiatrists get this question too, is like, families will come to us and say, we need a letter saying little Johnny or little Jennifer need guardianship. And I've had doctors who have come to me and said, Stephanie, can you talk to these families, because I don't feel like it's necessary at this point. What can the doctor do? Like, I mean, if the doctor doesn't feel like guardianship is needed, what's there? You know what I mean? Like, how can the doctor like just say no? Is it just say no and that's it? Or
Well, you know, that's a really good question, because yay, just say no is great, right?
Mhm.
Because there's way too many doctors out there that are like, oh yeah, I'll sign off. I've seen evaluations done on prescription pads. It's not an eval, but it's accepted. So,
Mhm.
I mean, especially I know that where you are, and these docs are really trying hard to like, wait a minute, you know, they can go, wait, okay, time out. I'll write a letter to this judge on my own
Mhm.
and saying, I've been seeing this person for 10 years, and you know, they don't need, I've been asked to do a letter, and I don't believe they need a guardian.
So you would encourage the doctor, they could possibly write a letter and send it to the court.
Sure. Or if they know that this person with a disability has an attorney,
Mhm.
call the attorney.
Yeah, try to work with if they're their parents wanting a guardianship to explain why the provider doesn't believe as they do.
Yeah.
So doesn't have that capacity, and what the problems are in his mind or her mind about trying to establish that guardianship.
So I don't, obviously I don't want to be the one that talks that family out of something that they really believe in, but I want to give them, I mean, my whole thing is, let's talk about this for a minute. Have you heard of the alternatives to guardianship? And so many of them tell me no, because the schools are like, oh, you got to get guardianship. He or she is 18 now. We don't have to talk to you anymore. Blah, 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 blah. And I'm like, well, stop.
Just having information sheets in the doctor's office about, especially when, in a setting such as yours, in which many of the patients have disabilities, that just as a matter of education.
Yes. Yes. Do you all have those documents?
We do. Sure.
So you'll email them to me?
We can
And
do
I'll
that.
make sure we get them spread around at KU.
Sure.
And
Sure.
That's true. That's just like with anything else. It's just providing families more information so that
Sure.
they have that opportunity to get a better understanding of what they're choosing to do. Because I know that once you've done this, it's really hard to get back out of it. And it doesn't hurt to practice supported decision making. Like, okay, they're 18. If you haven't practiced it, which I'm sure you have actually practiced it their whole life, let's do this for a couple of years. And if you really feel adamant in a year or two that, yeah, you need guardianship, then you can go after it then. That's what I try to encourage people. Here is another question. What is the process in getting guardianship? Is this something we can talk about once an individual graduates high school?
Well, the guardianship code allows for establishing guardianships of minors in certain cases, but the vast majority are for adults. But the process can start shortly before a child turns 18, but it depends on what is specifically the request is as far as in the petition for guardianship, whether it's, you cannot establish a guardianship for an adult when when the ward is 15 or 17. You have to, the person has to be an adult, and it can't just automatically transfer. It's my understanding from guardianship for a minor to become, and then it just automatically becomes one for an adult. You have to go through a separate process.
Anybody have any other questions? If there is, oh, another one came in. What if guardianship is the right decision and there is documentation from doctors, but you don't have financial resources for an attorney?
Kansas Legal Services provides some assistance in that area. We do not. Other than that, I don't know of any low fee process other than working with, some attorneys may take payments over time. It's a matter of negotiation perhaps. But, I just want to shortly explain what our office does, because the question came up about, how we would advise somebody who has no capacity, and that's pretty obvious, and why we would not talk with the parents, proposed guardians about, and give them advice. Our office, we're statutory creatures. We're private nonprofits, but federal law has required states to have offices like ours. And we're virtually all private nonprofits now throughout the United States under federal law for people with disabilities. And we're funded that way. And our funding is that our clients are people with disabilities in a wide variety of areas. We don't charge for our time. If an individual who is 18 who has capacity, in our judgment, wants to include parents in their decision making, all they have to do is give that authority to us, just as Kip was describing supported decision making. That to us is that individual's right to help him or her make those choices with whomever. We often get caregivers who that person said, yeah, talk to that person, help me out here with this. If any, we're happy to talk with parents, with adult children with questions. They are, for minors, they're natural guardians, and so they do have the legal decision-making authority. And so we will often work with parents with children with disabilities on issues that relate to their individual rights or needs.
All right. And here y'all didn't think you were going to have enough to share and talk about. It's 7:28. We did it.
We did it.
We hope we didn't put anybody to sleep.
I want to thank you both, Lane and Kip, for joining me tonight. I really appreciate it and sharing this information. I know it's really needed for so many people. And if anybody has any questions in the future, please feel free to reach out to the Disability Rights Center around guardianship or supported decision making. They're happy to talk to you. As Lane said, if you have an adult individual with disabilities. So thank you all for joining us, and I hope you have a wonderful evening.
Thank you for giving us the opportunity.
Thanks.
Absolutely.